Good morning, everybody. Now we're here for another TMA event to talk about the use of Chapter 11 by non-US companies. TMA Brazil, once again, want to thank its institutional sponsors. And now I'm Paulo Campana, partner at Campana Pacca Advogados. We'll talk to the Honorable Robert Drain, bankrupt judge in the United States, Lisa Schweitzer, partner at Clearey Gottlieb, and Guilherme Bechara, partner at Demarest Advogados. And we also have as reporter Camila Tebaldi, partner at Ferraz, Camargo, and Matsunaga Advogados. For everybody watching us, if you want to leave any question or any message to talk to us, you can do it on the chat on YouTube. Please do so, and we will answer as you ask. Right. And now we're going to start without any further delays because we have a lot to discuss here today. Right. Basically, we're going to talk about today the use of Chapter 11 proceedings by non-US companies. And we're seeing an increasing number of non-US companies filing Chapter 11 cases, reorganization cases under the US Bankruptcy Code to restructure their debt and their capital structure. We're watching also some Latin American companies file for Chapter 11 in the US, including Aeromexico, Alpha Credit, Maxon and Posadas, Automaipa, Gildemeister, and Avianca, companies from Colombia, Chile, Mexico. And we also have the case of LATAM, as you already know, which is based on Chile, but they also had a Brazilian entity which filed for Chapter 11 as well, right? And that's what we're going to talk about today. What's so attractive in Chapter 11 that so many companies in Latin America and in other countries as well file for it, right? So I would like to begin asking Judge Drain, why do you think that so many US companies file for bankruptcy in the US?
Good morning, Paulo. I just want to make clear, I am a recently retired bankruptcy judge. Retired.
Okay.
And I actually just became a counsel to the Skadden Arps law firm, but was a judge for 20 years and dealt with a lot of cross-border cases, of course. So what makes Chapter 11 attractive to foreign companies? Maybe the first point is that it's easy to file Chapter 11 in the United States. The only real requirement, at least to get into bankruptcy, into Chapter 11, is that you have property in the United States. And that property could be very small. It could be a bank account that holds just a fairly small amount of money as a retainer for counsel, for example. It can be a claim that originated in the United States and that the debtor has. So access is easy. That ease of access sometimes, of course, creates problems of enforcement, which we'll talk about later, as well as comity issues. But access is easy. Upon the commencement of a case, and the court does not need to make any findings if it's a voluntary case for it to commence. A petition is simply filed on the docket. The automatic stay under the bankruptcy code goes into effect automatically. There's no court ruling. It's part of the statute, and it purports to have global reach. It protects the debtor from actions anywhere in the world, and its property anywhere in the world. So certainly to the extent that the automatic stay can be practically or practicably enforced, that has a significant effect in terms of either halting or creditor actions against the debtor, or causing creditors to think twice before continuing to pursue actions against the debtor, even if those actions are in Brazil, for example, or in the Netherlands, or wherever the property of the debtor exists. In addition to that, Chapter 11 now is well established. It's been in place since 1978. There's considerable case law interpreting it. So it's generally pretty predictable. And obviously predictability is very important for a company that's in financial distress. The courts in the US are specialized in that the US bankruptcy system has its own set of bankruptcy judges. There are about 350 in the country who decide only bankruptcy cases and the proceedings and motions and contested matters within them. And the courts in the US, particularly several courts that have natural locus for foreign proceedings, Southern District of New York, Miami, Southern District of Florida, Delaware, other courts that have well-developed corporate understandings and also know the transnational nature of the world today, are now really quite well versed in the aspect of Chapter 15 that is not limited to just recognition of foreign proceedings. Chapter 15 of the Bankruptcy Code also directs mandatorily the courts and the parties appearing in front of them in transnational cases to cooperate with other jurisdictions where there are potentially conflicting jurisdictional issues. So the potential ultimately for coordination and harmonization in the inevitable often instance where there might be a jurisdictional conflict is there. There's a framework there to deal with it. So those are just a few of the things. There are other aspects that, and I don't want to monopolize this, that are attractive about Chapter 11 as well. And I could go into those, although I want to give other folks a chance too to talk about how Chapter 11 can be attractive in terms of dealing with the immediate needs of a functioning debtor that's in financial distress.
Okay, thank you. Lisa, perhaps you would like to add something else as well.
Sorry. I think one thing to consider in terms of picking forums also is when you're dealing with counterparties is what the counterparties to your business are comfortable with. And that very much depends on where your customers are, where your suppliers are, where your lenders are. And if it's you have very local creditors, you tend to want to file locally, both because they understand the proceedings and they are comfortable with the process. in multinational companies or larger companies, they often have exposure to different legal systems and are comfortable with the process that they know about. And certainly Brazil is a wonderful country with a robust process, and that makes it a desirable choice. I think sometimes, like in the airline cases, we were dealing with the lessors or international lessors of aircraft with New York or UK law governed contracts. And they're very comfortable with the US bankruptcy process for rejecting aircraft and renegotiating the aircraft. And so there's almost a game plan that you can follow. So I think in choosing forums, you want to think about that as well.
Yeah, and that's a very good example, right, Lisa? Because the opposite would not necessarily be true. I mean, specifically for airlines, perhaps the history in Brazil is not very attractive in terms of, reorganization proceedings and for airline companies. And the history of Chapter 11 for airline companies is quite good in the United States. So we had like plenty of successful stories of airline companies filing for US Chapter 11s and restructuring and even filing again. So this also is an important element of, culturally speaking, you have a history of successful cases and counterparties, they feel comfortable in going to that proceeding because they know what to expect. So sometimes for specific industries, it makes a lot of sense for you to think about going to a different jurisdiction, and particularly the United States, because you have a history of cases, you have precedents, you have a well-established, I would say, set of examples that you can draw on to think about how to restructure your business when you're thinking from the standpoint of the debtor.
So both of you highlight that it's really important to focus on the specific types of creditors that you want to affect in the bankruptcy case. And if they're financial creditors that have a major presence in the US, or sophisticated creditors who are used to the US system, then there are tools in Chapter 11 that can be used, such as expedited prepackaged type of bankruptcy, where the creditor group that's affected by the bankruptcy is relatively narrow. It may just be the financial creditors, for example. You also have, and this is important, although maybe not as much when you're comparing potential forum Brazil versus the US, but in other countries it's important. You do have access to DIP financing, that is post-bankruptcy, post-petition financing in the US that has a pretty well recognized model for implementing it, and implementing it quite quickly with interim financing in the first days of the case. And that's obviously important since cash is the lifeblood of operating companies.
Yeah, you're right. And as Guilherme mentioned, there are some specific industries that benefit a lot from filing in the US, right? You had several cases here in Brazil where airlines filed for judicial reorganization and things didn't go as well, to say the least, right? While in the US, they managed to actually restructure, right? And perhaps one of these reasons is the likelihood of the company obtaining financing, which is in Brazil, we had hopes at least that this would work, right? But and we have an amended law now, and we have renewed hopes that it can foster financing, but we're not 100% sure if it will happen or not. While in the US, we have a history of cases and legal certainty, right?
Yeah, I think I think the new law is a great improvement, I have to say, from what I understand from the prior DIP financing law in Brazil. And I trust it will be implemented. But there are a number of countries where there is no such ability to obtain post-petition financing, and certainly not to prime existing creditors. And so obviously it's a large risk for the lenders, and they're just not going to provide that type of loan post-petition. The U.S. code also, and I should mention this, has statutory mootness provisions, which make it more difficult to pursue an appeal of a DIP loan or a sale or a transaction out of the ordinary course, unless you persuade the judge to stay the effect of that order. And that gives a fair amount of certainty and makes the case move faster in the U.S.
Guilherme, do you want to comment something on the Brazilian law that makes?
No, I think that honestly, I'm very optimistic about the DIP here in Brazil. I think that we had like an improvement concerning the reform, and I think that is yet to be seen. This being implemented. I think that we already have good examples. I think that it's a little bit different, at least from the experience that I had with Lisa and the cases we work together. It's different how it works in the US in terms of how the DIP is structured, especially the DIP itself, which is, and Lisa can comment better, of course, but it's designed to be paid throughout the proceedings, so it's not something to go long term in terms of financing. So it's a short term financing designed to help the company to navigate the proceeding, and then the company is expected to find new sources of financing to exit the proceeding and to find a new capital structure. So it's a different type of DIP as the ones we see in Brazil. But I'm very optimistic. But I think that, and perhaps Lisa can help me here, but I think that the access to financing is also a big driver when debtors are looking at which jurisdictions they may file, so because we all know that new money is definitely a big issue when it comes to restructuring, right? And we know that the United States has a big market for DIP financing, so access to financing is an important thing. And so the access to the market itself, it's one thing, but there are also legal issues, I think, that from the standpoint of both US and local law that play a role, because creditors sometimes they want the companies to be in the Chapter 11 because they are under the purview of the bankruptcy court. So creditors may feel more comfortable because they make sure that the super priority of the bankruptcy court actually apply to those entities because they are under, the court supervised proceeding of the U.S. Chapter 11. But the big issue is the interplay, between the local law and the U.S. Chapter 11 proceeding, and how do you enforce this in your local jurisdiction if you need to enforce like collateral over local assets and so on and so forth. But, putting those, I would say, non-U.S. subsidiaries or entities in the U.S. Chapter 11, sometimes it's important because the DIP lenders may feel more comfortable because, those entities will be under the perimeter of the bankruptcy court and under the, all the purview of the protections of the U.S. Chapter 11. But Lisa, please, just, it's much more a U.S. law than Brazil here.
Yeah, no, you're exactly right in everything you highlighted. I think that the U.S. compared to other jurisdictions has just a more robust history of giving DIP financing. It's got very clear rules for it. As Judge Drayton knows, that once you lend the money, that it can't be avoided or recovered, or the loan can't be challenged and relitigated on the terms. So you can say, don't lend them more money, but it's kind of locked in once the loan is approved. So it's lender protective. I think the interesting thing about it, when you think about it for a multinational company or a company that's based outside of the US, is that one of the biggest advantages of the DIP loan in the bankruptcy is that it gets the super priority claim ahead of all other creditors, ahead of pre-bankruptcy creditors, ahead of post-bankruptcy creditors, ahead of the lawyers, and lawyers always come first. And so you're really at the top of the stack in terms of getting repaid in the Chapter 11 plan. You also have the ability that the court, merely by entering an order, gives you a perfected lien against assets. You have a second lien behind other perfected assets, but you also have the ability on the proper showing that you can actually prime other creditors. Usually priming and leaping ahead is done on a consensual basis, and we could spend a whole day talking about priming liens and all the other things you can get in DIP financing. But the idea is that you're getting this perfected lien, and so that again, you have kind of two protections. You're secured against the assets and you're first in line. And it's kind of the bookends of the same protection, is that no one gets paid before you. And as Guilherme said, that it's also the expectation is you're going to be paid at the end of the case. And if you're not, you basically have a lot of power about what the remedy, short of getting paid and getting repaid in full, would look like. Whether it's you're taking the assets of the company, you're taking equity interest, you're really first in line for bargaining if you're not paid in full. And recently we've seen DIPs proposed where you can even convert the DIP into equity of the company at a pre-agreed rate. That's more controversial. Some courts have allowed it, some courts haven't. But the idea is that whether it's negotiated up front or later, you're going to have that kind of pole position. The interesting thing when you're dealing with a non-US company is that you can get all the orders and protections you want in the United States, but if your collateral is an office building in Brazil, the fact that a US court entered an order saying you have a lien against that collateral doesn't mean you don't have to go and perfect that lien locally. So you still have to go and do actual perfection against assets outside the US. The second thing is that if in fact the case were to go bad and it were to completely unravel into the company turning into liquidation, thankfully we haven't really had that happen in cases, but there'd be a question of whether that liquidation would actually or practically occur in the US court, or would it predominantly occur under local law? Like how much could the US court in the end prevent people from seizing assets locally if they weren't subject to the stay, or how much would people want that to be the outcome of running it through a US Chapter 7 or liquidation in the US process? And if you were to go locally and you needed to go, and even if you said, fine, I have this Chapter 11 order and I have this order that says I can go enforce and get first rights against these local assets, and I have this magical super priority claim, and that claim goes ahead of employees, even though under local law, employees get preferences or whatever your example is, would local courts really respect that? That's a harder question. And when you go to get, and we'll talk about it separately, but you need to get these orders recognized locally in order to get that sort of protection later on. So that's one of the issues. You really are, in my mind, investing for a reorganization. You're counting on the fact this will be a reorganization under a Chapter 11 plan. And if it is, you have really good protections. If it were to go completely sideways, there are harder questions raised. Lenders have also, in some cases, raised the question of where is the cash actually being held, for exactly this reason, that they want the cash to be held in the US, in the theory that the US court can direct the debtor in how to use that and to apply it, to use it to repay the loan if things go bad. But it's sometimes inconsistent with the fact that you have a company largely operating outside the US to require them to hold the cash in the US. So you have to, as a lender, realize that as you're lending into a situation where a decent amount, if not the majority amount of your cash that you're lending will actually not be held locally. And so that's another limitation on remedies later. But I think that as you've seen in several cases, in the US, people are willing to lend as long as they feel comfortable that there's a reorganization prospect, and even things quote unquote going badly still will be resolved through a Chapter 11 plan ultimately.
Exactly, and two points here, and we may talk about this later. Even on the issue of preferences, not preferences but privileges. Even if you get the order recognized, you have public law exceptions, right? I mean, so you may get the super priority order recognized, but when it comes to some issues like labor law or even tax law, to what extent those credit priorities fall within public law exceptions, and courts in local jurisdictions would find that those credit priorities would fall within those the public law exception would also be a question, especially in Brazil, that we have not yet tested the model law. I don't know, Paulo, you have studied quite a lot the model law in other countries, and also I think that, Lisa, this issue of the cash is also another point I think of concern when you think about putting your subsidiaries into Chapter 11 or not, because if you need to flow the funds to subsidiaries to capitalize them, then sometimes you need to put these subsidiaries into Chapter 11, because then at least you have the whole system into Chapter 11, and lenders feel comfortable that even if the cash is not in the United States, at least you have the whole system of companies into the Chapter 11. So at least you get them under a reorganization plan afterwards.
Yeah.
One point that Lisa raised, and I think it would be interesting to get your comments as well, Guilherme, is that in addition to priming, which we have already discussed a lot, right? There is another issue whether the assets are in the US or outside of the US. And therefore, with assets here in Brazil, there is a concern that not only the preferences will be respected, but that the creditor will actually be able to get their hands into the asset, right? Because one thing is what the law says and what the priorities are, and a completely different thing is the ability of the creditor to actually enforce it, right?
Well,
yeah.
And I think that's the importance of perfecting the collateral here in Brazil, and the type of collateral that you choose, right? I mean, I think that we have powerful collaterals here in Brazil. Of course, everything is subject to litigation, we know, but I think that there is I mean, if you get like a fiduciary liens, fiduciary collateral, we are much more protected than if you choose to get mortgages or other type of collaterals. So that's, I think, the importance of, this interplay between the priority you have in the US, which is an order from the bankruptcy court, and choosing the collateral you have in your home country, in our case, Brazil, and taking all the steps in Brazil to perfect this collateral, regardless of any, I would say, order from the US bankruptcy court. And then you can also think about, the recognition issue. And I think that if everything goes south in the US, then it's a big issue of how and which measure you would take in Brazil, either in court or out of court. But honestly, I think that if you have the right collateral and you have a recognition proceeding, I think that courts in Brazil would give deference, especially that if you have, like, for instance, in a deep financing that we know here in Brazil, and we give a lot of deference for deep financing in Brazil. I don't see why a court in Brazil would not give the same type of deference to a deep financing given abroad.
Okay, that's
but
great.
Again, we have not yet tested this. But I think if we give that type of deference to a deep finance in Brazil, with courts in Brazil, with our bankruptcy courts, they have this mindset, and we know that they know that this is important, and they give a lot of deference to that. I mean, it's the same rationale.
So perhaps what you're saying is that if in the US at least, the investors would have a greater peace of mind that things will go well. And in Brazil, it has not yet been fully tested. So we'll still have to see, right, if everything will go as planned.
Yes, but that's true. But that's the importance of not relying only on I would say the U.S. type of protections. You also need to perfect your collateral here and structure your financing as a secured financing here in Brazil the same way that you would do if it wasn't a deep financing in the U.S.
Okay, that's great. Now talking a little bit about the stay of proceedings that you get in the U.S., right? Robert Drain, I would say Judge Drain, but I won't, right? Talked about the global.
I still call him Judge Drain. You're allowed to call him Judge Drain.
Okay. Judge Drain talked about the global stay, right? That you get in the U.S. But then how it does work out, right? In other jurisdictions that you have to have other countries recognizing that global stay for that to be truly global, right? And how you do that in Brazil? I mean, you have the model law implemented in Brazil after all, and we have just 2 cases, actually 1 case, right? Because the other was dismissed. And we don't actually have a body of court precedents here, and we have several questions, right? Whether you have, as Guilherme mentioned, a subsidiary of a multinational company may file in the US, and that's one thing. Another thing is, what if I'm a Brazilian company, and the headquarters are in Brazil, and then I decide to file for a Chapter 11? Would Brazilian courts recognize that, and how they would recognize that as a foreign main proceeding, foreign no-main proceeding? How that would work in practice, right? That global stay.
Right. Well, it's the it's the fundamental question in any transnational case, and I think it's probably best to view this as, an initial position and then a fallback position and then a further fallback position. So assume first that you decide that you're really going to just try to affect certain groups of creditors. You have the types of sophisticated creditors that Lisa and Guillermo talked about. So you file your Chapter 11 case. And only that case. You don't seek recognition of it anywhere at that point. The stay is enforceable only to the extent that there is power to punish a party for violating it. So if they don't have a presence in the US, if the creditor has no property here, the U.S. court will not be able to enforce that stay. It would have to go to the foreign court to enforce it. In addition, in the U.S., there is an issue as to personal jurisdiction. So you would have to get personal jurisdiction over the violator of the automatic stay in order to enforce it. This came up in one of the very first transnational cases, United States lines, where a company that provided goods, for a maritime lien, arrested a vessel. They had no property in the U.S., so it didn't matter that the judge implemented a fine of $1,500 a day, which mounted up quite quickly because you couldn't collect against them. You had to go to the foreign court. So it's become really quite recognized that if you file a Chapter 11 case with foreign creditors and their critical creditors that don't have a presence in the U.S., you're going to have to pay them. I mean, they just have that leverage. On the other hand, there's step 2, which is to get recognition of the U.S. case in the foreign country where the creditor is, or the creditors are. And then finally, if you're going that route of an initial Chapter 11 case, you may well have to be prepared to actually file plenary cases in the foreign jurisdiction if they permit it and it doesn't put a monkey wrench into your whole process. Although having multiple plenary cases is expensive, obviously, and there are heightened coordination problems because you're not just coordinating among creditors and the debtor, but you're also coordinating among courts as well as the other parties. So I look at it in those sort of three stages. I think you have to do that advanced thinking if you're just going to think about filing first in the U.S. Again, as with the DIP financing discussion, enforcement is the key. So it's hard, for example, to envision a Chapter 11 case in the U.S. with substantial foreign creditors and mostly foreign assets, unless you have the cooperation with the key foreign creditors. That goes for DIP financing too. If they have liens, they're probably the likely DIP lenders also, because then they can assure themselves that they won't stand in the way of their DIP financing. Anyway, that's a long-winded beginning to this, but you never really do get around those issues, those enforcement issues.
Let me ask you something, and also to Lisa, right? The willingness of courts in the U.S. to cooperate with foreign proceedings and to recognize a foreign proceeding under Chapter 15. Do you think that that makes a Chapter 11 less attractive to some foreign debtors? So because that would lead to this additional costs and to the need of coordinating different proceedings, while you can have a foreign proceeding which is recognized in the U.S. And perhaps the reason for filing in this cases would be the efficiency of the U.S. proceeding, the likelihood of getting a DIP financing, and this kind of real advantages. What do you think about this?
Yeah,
I don't know. I know that isn't on the script, but that's something.
I think your list is exactly the types of things that people think about. I think any responsible advisor to a company that's facing distress doesn't start with like a hometown bias that you definitely should always go to your place where you're incorporated, or you definitely always should go to the U.S. because U.S. is best. There's no such bias. You literally, like in Latam, we sat and thought about, first, no one wants to file for a proceeding anywhere. No company is looking to hopefully file for bankruptcy or any RJs, EJs. No one's looking for that, right? Everyone's looking for out-of-court solutions. And then you think, if that's not going to happen, where can you file? And what would be the pros and cons of that? And you literally map that out and say, if I file locally, I have the local creditors, but I don't have any money, so that's not going to work, right? Or if I go to the U.S., I get money and I get my financial creditors, but the local creditors are going to be a challenge. Or I'm going to, aircraft are flying all through the world. Where can I avoid people from taking back my aircraft? Or, you literally map out all those pros and cons. As Judge Drain said, you do two proceedings and have them work together. In the U.S. and Canada, you can do two proceedings, work together, and the proceedings generally work in the same manner, in the same pace, in the same types of orders. That works really nicely. But when you go into Latin America, Brazil, other regions, it's just a different timeline. It's a different process, and it's not running them parallel. They sometimes just don't really work together. To have, one of them needs a plan in 2 months, another one you can't have a plan in less than 4 months. They're like logically inconsistent. So you are going to weigh all of those thoughts. I think the one thing we also haven't talked about And I know something you see in Brazil and in the US is filing companies that have multiple subsidiaries or affiliates in different countries. So Brazil, you certainly have experience filing cases where you have financing subs and other affiliates that are not Brazilian entities and bringing them into a Brazilian RJ proceeding. In the US, in the same way, you can bring companies, not just the Brazilian company, not just the US affiliate, but people in affiliates in different countries into one proceeding. And that often winds up being a tipping point when you decide to bring a foreign company in. I would say that plus dip financing probably, and the fact if you have international debt, the non-local debt, are probably the three biggest drivers of coming to a US proceeding as opposed to staying a local proceeding. But every case you have to do that analysis on a fresh piece of paper to think about the pros and cons. The only thing I would add, and I know I want to hear from other people as well, is that the Comey analysis is very interesting also, right? Because I think that we all have a model law. The model law says that, the main proceeding is in the center of main interest. You always think, well, I know exactly what center of main interest is, the heartbeat of the company. And it's an interesting question in that in the UK, if you take a non-UK company and file it into the UK and you appoint an administrator, there's case law saying that becomes the Comey. The administrator has taken over. In an operating company that's outside the US, you usually think, okay, you're filing a US proceeding. It's probably not a main proceeding. In LATAM, we got the Chilean parent proceeding recognized as a main proceeding in Chile, first of its kind to do that. But one of the things the local court looked at, and it wasn't contested, but one of the things the local court looked at is said, you just borrowed, $2.5 billion in the US under a US court order. Feels pretty mean to me at that point, right? Like that's where all your fleet restructuring is happening, and that's where your dip loan is. And like you might have operations other places, but even without an administrator, that it did become almost a self-fulfilling Comey once the case was filed. Is that right? Is that wrong? Could people argue otherwise? Could there be more than one Comey? I think those are going to be questions that come up in future cases, or maybe it's case specific, or maybe it's where people don't fight it. You can get those kind of filings, but really interesting questions coming up in these cases.
Yeah, I would just add, I mean, that's all extremely thoughtful, and I agree with it completely. Going back to your initial question, Paulo, I think the US courts are generally quite ready to grant recognition if something really does look like a main proceeding. And as Lisa said, things are already moving there. Things are from the commencement of the Chapter 15. You look back to what was happening in the foreign proceeding, and if it's being run actively and people are relying on the steps of whoever the foreign administrator was, that it's likely it'll be recognized. And certainly, the US courts have recognized multiple Brazilian proceedings in Chapter 15 cases. And I think as the model law spreads throughout the world, including in terms of experience in using it, courts will start thinking that way, because ultimately the model law is intended to be a practical statute, to maximize value by coordinating these cases within basic limits of fairness. And as long as I think the debtor, the foreign representative, is not taking undue advantage of some group, particularly of the local creditors, you'll get recognition, and you'll get a practical recognition if, in fact, you need to coordinate. And I think the judges that have been addressing these types of cases, through the Judicial Insolvency Network and other contacts, really do appreciate this and look for that type of explanation. I'm sure that when LATAM sought recognition in Chile, it explained that policy, quite articulately. And I think that's really important. And it's consistent with the statute.
Yeah. Paulo, I was just listening here because we have no experience at all, right?
But I'd like to hear your opinion on some things that.
Yeah, I know that. Last afternoon, you threw here a curveball, right? You said, would the Brazilian court recognize a Chapter 11 as a foreign main or non-main proceeding with respect to the Brazilian subsidiary? And I think that's the $1 million question, right? And I think that the COMI analysis in a group of companies, I think that is still it's the big question. Honestly, I don't have an opinion, but I truly hope that Brazilian courts will draw on the international experience, so the Brazilian courts are aligned with the international experience on that. But we have not had any experience on that. I mean, I think that we have just one case, ProSafe, right, which was uncontested, right, and it was specifically designed to protect a vessel. So you didn't have a lot of discussions about COMI jurisdictions or the like. But I'm more inclined to say that in a first reaction, I think that perhaps courts would be more inclined to. I think that depends on the level of activity of the subsidiary. I think that if it's a operational subsidiary with tons of activity in Brazil, a lot of employees, then courts would be more inclined to see this as a much more Brazilian company than a piece of a whole structure. So if it's like a sub, not much operational, then I think that courts would be more inclined to consider as the proceeding as a main one. I think that. But again, it's just a guess.
Can I throw out a hypothetical, which is, what if it was made clear to the Brazilian court that the local subsidiary really isn't going to be affected except by benefiting from the continued flow of funds, that you're not looking to prime the union employees, you're not looking to prime the employee. At that point, I would hope that it wouldn't be parochial and say, well, okay, I understand that this is for the good of that subsidiary and those people.
I think that's a good point, Judge Drain, and I think that depending on which debt you are impairing in the Chapter 11 proceeding or in the foreign proceeding, right, Paulo? I think that would be also a factor here. If you're trying to impair all claims like labor claims, general unsecured claims, then the court would be more inclined to say that it's a non-main proceeding. But if you're only trying to impair financial creditors located abroad, if you have like a pre-packed Chapter 11 only for U.S. denominated bonds, then perhaps courts will be more amenable to consider a main proceeding.
What I would also like to ask you is, for instance, in Brazil, we have lots of court precedents stating that the group of companies may file together, and the venue where they file is the principal place of business of the whole group, right?
Yeah.
I have subsidiaries, I have factories statewide, but I choose to file for all the companies in just one venue, which is the principal place of business. Like the Brazilian court could, right, look at a multinational insolvency, a multinational group, and say, look, we have a Brazilian subsidiary here, but the operations of the group, the center of main interest of this whole group, although the Brazilian subsidiary doesn't have operations in the U.S., the whole group is based in the U.S. The COMI of the whole group and not of the individual entities is in the U.S. Do you think that a Brazilian court would accepts such argumentation to allow a foreign main proceeding of a Brazilian subsidiary using that kind of argumentation. What do you think?
Well, that would be the same rationale, right? They should. Well, they should. I mean, if you have like I would say the board, the main, I would say the decision-making process of the whole group is located in New York, to say so. Well, that is the same thought process concerning at the local level, right? You have like factories, you have industrial premises all over the country, but you have let's say the Brazilian operating the decision-making process in Brazil located in São Paulo, the city of São Paulo. So you file in the city of São Paulo. If you expand this to the world, then you can say that, the decision-making process of the whole group worldwide is made out of New York. So you can file in New York, and that should be the COMI of the whole group.
But, this issue is bedeviled,
Yeah.
the law everywhere, including the US. And Untertraus, really trying to deal with groups still, and it's complicated by the British and the Gibbs rule and all. It's still kind of a mess. And even in the US, the courts have adopted a kind of a nerve center approach, and certainly in OI, and I hope I'm pronouncing that right, and OAS, that was important in dealing with the foreign financing sub. But those subs didn't have much life besides just being a financing center to get fundamentally a lower interest rate. So the courts are careful to say this is really a discretionary determination, looking at a number of factors. And I even think a US court might say, I might not recognize as a main proceeding, a Brazilian case where it covered a US company that had significant operations, significant employees, and its own management, some independent board members. I think at that point you're in the realm of I won't recognize it as a main proceeding for this company, but we'll coordinate. And of course, the debtor at that point will probably have to file either seek non-main recognition or file an independent case in the US. So I think the facts are really important here.
Yes. Thank you, Virginia.
Yeah. And well, a little outside the scope of the things we want to talk about, and I know we want to talk about a lot of things. I think the coordination point is another interesting thing that in practice, we've often put in protocols where the courts can talk to each other. There are the standard protocols you can use and adopt. I find that those routinely result in reports being filed for the other courts. And I think it's really important to keep both courts informed about things going in front of the other court. Just the judges should not be behind anyone else and shouldn't be surprised and read about things in the paper that are going on either in the main or ancillary proceeding. But I think that it's interesting in that most of the courts don't wind up talking to each other either on an ex parte basis or on a coordinated hearing basis. But that's also something you can offer to the courts in the right case with the right judges to make sure that everyone feels that there's alignment and comfort with the way the proceedings are going forward. And also, because I think we've seen probably in both directions, but more likely just Brazil to the US, just because of the way the case has been filed, creditor objections double dipping, right? That they try in one forum, they go in the second forum if the first forum doesn't work. And everyone, if you don't want that to happen or you don't want that to successfully happen, I think all the parties have to be really thoughtful on process and on educating the courts along the way as to what's happening, so that the ancillary court can take comfort that the main proceeding is fair and is addressing things and with appropriate due process and appropriate consideration for the international issues at play.
Yeah, I do want to highlight that the GIN guidelines have now been adopted in many individual U.S. courts, SDNY, Delaware, SD, Florida, Texas. They've also been adopted in Brazil and in other countries, commercial countries, UK, Singapore, Hong Kong, so it's more than just the proclivities of a particular judge. They're actually, either practice guidelines or rules, depending on, the local form. And they provide a structure that should give comfort to judges on requiring periodic reporting, directing the parties to coordinate. And and I agree with Lisa, this is a rarity, but it does exist, having mechanisms for court-to-court communication, particularly if the process goes crosswise. If you have completely dueling orders, didn't tell the judge that this was a possibility, and then the judges have to sort that out. So those are in place, as well as procedures for contacting the courts if need be, also through the Judicial Insolvency Network guidelines.
You mentioned, of course, the possibility of court-to-court direct communication, and that's something that I would like to hear on your experience and about what Guilherme thinks about court-to-court communication between right.
Well, although I have to say, sometimes we think we're speaking English with UK judges, and we're really not. It's a different language there too. But I actually have had, when I was on the bench, communications with Brazilian judges as well as UK, Canadian. You have to be careful about it, obviously. I think it's important to let the parties know that this is going to happen and set it up in a way that's fair. And I think judges don't want to do it unless they feel it's really necessary. They really want the parties to coordinate. And you can certainly send a lot of your messages through what you say on the record in court and directing the parties to deliver that transcript to the foreign judge. And the JIN did work out modalities of communication as well in terms of translations and getting comfortable to have something that is set up in a way that doesn't make either or both of the judges uncomfortable in terms of either language differences or time differences and the like. So those are public guidelines, and again, they've been adopted by many courts. So I don't want to run too far afield, because I think the main issue is the coordinating among the parties, and the judges, I think, are sensitized, and the statute directs you to this, to try to avoid opportunistic behavior, the double dipping that Lisa talked about, for example, and recognize legitimate differences between the jurisdictions. Like, I mean, in LATAM, for example, there was a need to preserve stock ownership. That's an important issue. And you have an airline that really needs to deal with that, and it may potentially run afoul of U.S. rules. But I think the judge in that case was quite sensitive to the transnational nature of that corporate structure and the regulations that underlay it.
That's quite something as well. I think it goes to our next topic, right?
Yes.
We have in Brazil, in the US, different priorities and different and especially to equity holders, right? In Brazil, they do not vote on the plan. They are not a class of clients or interests in the company, and you cannot simply cancel the equity and issue new equity to the creditors. So what about a Chapter 11 plan that cancels the equity and issues new new equity to the creditors, how that would be recognized in Brazil, and also wouldn't this be an incentive to debtors filing in Brazil instead of the US, as shareholders would have more bargaining power to keep their equity?
Yeah, so I'll start that. I mean, I don't think there's a right answer. Great question, not a right answer. I think that the shareholders always would want, shareholders are in the US last in line. There's just no two ways about it. You're last in line, creditors first and then shareholders. And it's pretty clear there's some exceptions for new value and all this, but shareholders come after creditors. In Brazil, it's not the mentality. The mentality is that you're compromising debt and you're not compromising shares. I think that goes when you say, don't those shareholders want to file a Brazilian proceeding instead of a US proceeding? If you look on that element alone, absolutely, right? But I think that goes back into what are the other things you're accomplishing in the proceeding. And everyone has to recognize that it's a collective proceeding, and everyone has to recognize that war or disharmony is worse than a compromise solution. And it's not just that you walk in and say, oh, my rights are my rights, and I'll give them up just for the sake of harmony. There has to be people advocating for themselves. But I think that if I were looking at it as a Brazilian shareholder, I'd say, well, certainly if I were the one making the decision where to file this company, and I thought that I, as a Brazilian shareholder looking at a Brazilian company, could successfully reorganize in Brazil, why would I ever go to the US? There is no reason to start going outside the forum. I think where you go outside the forum is for the reasons we said, is look, I can go to Brazil, but maybe I don't get DIP financing. Maybe I don't have control over my counterparties. Maybe the counterparties aren't willing to do business with me on a continued basis, or whatever it is. Or I'm part of a larger group. In LATAM, Brazil was part of a larger group. And we left Brazil out in the beginning because we were working through these issues, and you don't file companies just to file them for bankruptcy. I mean, it's disruptive to the business, and particularly with foreign subs, you try to keep them out. And in Brazil, we couldn't keep it out. They needed the cash of the group. They needed the DIP financing. They leased their planes from the parents. They were a separate entity, but certainly part of a group. And with that, you have to also account for the equity was internal, and the Brazilian creditors got paid in full. So we didn't have it from a Brazilian point of view. But in the Chilean parent, it was a very pronounced issue where creditors were getting less than 50 cents on a dollar on their claims, and the shareholders have preemptive rights. But also, it's not just shareholders as shareholders saying, I don't want to be wiped out. You have to look beyond that to the fact that you have a board in a local company that has local regulators and has local fiduciary duties and local governance documents that tell it what it's allowed and not allowed to do, right? And so I think you have to account for all of that in the mix when you come, if you come into Chapter 11, as Judge Drain said, you have tension between different frameworks of law that are applicable to this company, and you have to find a path forward that best accounts for those different rules that are, quite frankly, directly in tension with each other. But during the case, there certainly were creditors arguing, just go get, you're in the U.S., get a U.S. plan, cite blah, blah, blah provision of the U.S. bankruptcy code that says everyone just has to follow this and implement this decision. And, just show it to the directors, officers, creditors, whoever it is, shareholders, and tell them, you have to implement this decision. You have to affirmatively vote as a shareholder in your own country to waive your rights. You have to affirmatively vote, not just let things happen to you, but you have to affirmatively take action against local law to implement a U.S. plan. That's super uncomfortable. I mean, I never would want to be the person making that motion to ask a U.S. court to enter that order to tell people to take actions outside of its jurisdiction that are in conflict with local law. I mean, I think that's just a very hard decision. So in our case, we found a path, we found a compromise. We had mediation under former Judge Grapper, who was very attuned to all these issues and very experienced as Judge Drain is in all these international issues. And I think that was really helpful to have a third party talking about it from both sides, right? Because both sides are right. I think that the hardest part of it, quite frankly, is it's not a valuation fight. It's not a question of someone says the company's worth $1 billion and someone says the company's worth $2 billion and you split it in the difference. You have preemptive rights that either exist or they don't exist. If they exist, they come first. And so there's no mathematical solution. There's no amount of experts that you can show that says, here's a compromise valuation. It's truly, it's a negotiation, but it's hard to negotiate because what are your principles for the compromise? I think that was the hardest part of working through it. Everyone's better off with the compromise. No one can execute their side without the other side, but it's very hard to find the rules of the road for how to bring the parties into a compromise.
What if the company is, say, reluctant to file a Chapter 11 in the US? Could creditors file an involuntary case to force the company to file in the US? How bad would that work, right? Especially considering the assets. If the debtor doesn't pay the retainer fees to its attorney, how could that work out, right?
Well, you have the same very minimal property requirements, and it's fairly easy to file an involuntary in the U.S. But having said that, I think if it was truly a hostile involuntary, and the assets and most of the creditors were elsewhere, or there were major enforceability issues, I think the court would be very reluctant to proceed. And there are various avenues, even if the involuntary would normally succeed, to abstain or defer to see how things might play out in the center of main interest. So I think as a strategic move, it has not been viewed, that strategy has not been viewed that favorably in the US. Because again, transnational cases like this generally work, as Lisa just described, on ultimately on consensus. If it appears that some holdouts are filing an involuntary or trying to be troublemakers, I think generally speaking, the US court shut that down.
Yeah. Although I think that Judge Drayden, that someone just told me TVS Teca, there's a case pending now where there's an involuntary filed against a Mexican company, I believe, maybe, which is they're arguing about these very issues. So people
can watch. I mean, yeah, it's definitely it is unfortunately in some creditors' toolkit, but there's a fair amount of case law recognizing abstention if it's really just a hold-up ploy, as opposed to something truly legitimate, like trying to avoid an avoidable transfer that otherwise would pass through. And there are serious sanctions for improperly filing an involuntary. So it is somewhat risky to do it too, because if your voluntary is dismissed, you may be subject to serious sanctions.
Yeah, I agree.
Yeah,
That's
Paulo,
great.
I think that this issue of the shareholders is also, as Lisa mentioned, one of the important elements when deciding whether to put a company in Chapter 11 or not. And I think that there is a cultural element, as Lisa mentioned, that is quite important, especially because perhaps different from the US, here in Brazil and in a lot of Latin American companies, we don't have a lot of, true corporations, in the sense that you have that is first equity ownership. So we have a lot of closely held corporations, or even, corporations that have a strong controlling shareholder. So where you have like the shareholders actually, you know, in the management of the company, so you don't have a clear segregation between, you know, management and control. So, you know, making clear that, you know, you go to the United States and there is a different mentality in terms of, you know, what happens to shareholders is also important. And then as to your question that you made yesterday, would a Brazilian court recognize a US Chapter 11 plan that provided for a completely wipe out of the shareholders, or, you know, conversion of debt into equity? That's a good question. I mean, and whether this would fall within the public policy exception. I mean, there is inconsistency, right, between this and our corporate law. As we have in our bankruptcy law, when you look at the creditor's plan, the conversion of debt into equity in the provision of the creditor's plan in our corporate law, right? If you think that you always need the shareholder to have an affirmative vote, to have the preemptive rights, there is an inconsistency between, you know, a completely wipe out, a forced conversion of that into equity, or, you know, a new equity offering without the shareholder. So all of these violate Brazilian corporate law. If this violation goes to the realm of public policy exception, then it's a different question, especially when you look at the model law itself that says that public law should be interpreted narrowly. So this is, you know, corporate law. We're dealing with sophisticated players. It's an issue of equity ownership. It's all about money. So honestly, I have doubts whether this would fall within public law. Man, but definitely I see shareholders arguing that it's a fundamental right. It's a fundamental shareholder right. It goes to the realm of property rights, and property rights are issues of public public policy under Brazilian law, because it's property, right? Essentially, you are being expropriated, and expropriation without due process. So you can be creative, right? You can go all the way to the Constitution to say that this would violate your property rights, and then it falls within the public policy exception. But I have serious questions whether this would fall within the public policy exception.
You know, perhaps one thing is to debate, as you said, we have sophisticated players here. Perhaps we do, perhaps we don't, because if you think about the controlling shareholder, perhaps that's the case.
That's right.
But if it's a listed company with a very small shareholder,
Excellent point. Yeah. Excellent point. I mean, sometimes you have minority shareholders that are completely, you know, not even aware of all of this, and they will be completely wiped out without any notice, whatever. You have a good point.
Now going to the next topic, would you like perhaps, Guilherme, to defend Brazilian jurisdiction? And I don't want to put you in a difficult position, but would like to defend Brazilian jurisdictions. Is it cheaper? Is it more debtor friendly? What are the advantages of filing here in Brazil? Why they should file in Brazil and not in the US?
No, I mean, I think that it's not a matter of defending, but I think that, honestly, in Brazil, we have a robust system. I mean, it has been tested. Brazilian law works. The Brazilian insolvency system works. We have the recent amendment to the law. It's a framework that, again, has been tested. We've had like tons of big cases. We've had deep financings. So I think that what we've seen, especially during the pandemics, is that you have the US Chapter 11 as an option, right? I mean, I think that it's good news. It's not a tension, perhaps. Perhaps the Latam case has proven that, well, I mean, there is another avenue that Brazilian companies can explore, right? So I think that it's not a tension, you know, I think that it's not a matter of defending the Brazilian system. I think that Brazil is a very good place to restructure, honestly. I think that, especially when you look at São Paulo or Rio, even, you know, Minas and other places where you have specialized courts, you have, you know, sophisticated advisors, good people working on the restructuring fields. The restructuring market has grown in the past years. So I think that here we have a good system. Companies have restructured, have successfully undergone restructuring proceedings, but now you also have, especially for cross-border cases, an avenue to explore, which is a Chapter 11, US Chapter 11 proceedings. I think that in the past, no one discussed this possibility, and now you can also consider a US Chapter 11. Again, there are, you know, a lot of things to consider: costs, cultural elements, your creditors, your other stakeholders, your shareholders, everything. But, you know, again, it's another option.
To second in on that, I say that I agree with everything you said. I think two of the really important ones are a track record and history of reorganization as a bankruptcy goal, because I think of many countries outside the US, reorganization is not the primary goal, or not, you know, that it's bankruptcy means liquidation, or that there is practice that there's not successful reorganization examples. And the second one that you said, of a robust and a sophisticated court system, is hugely important as well. I mean, there's millions of other factors, but I think those really distinguish Brazil and make it a very desirable forum for people to seek a reorganization process, even if you're in a
Yeah, I agree. I mean, I've been coming to Brazil since I think 2004. You know, I had the Varig 304, and that the sophistication at this point is just, it's great, you know. And so, and the U.S. courts recognize that they are quite comfortable with the Chapter 15 recognition if you need it. So it's a Chapter 11 may be a tool if you have a group or some other rationale, but it's a very fact-based analysis, and there's a lot of good facts for Brazil.
Before we wrap up, I'd like to. There is another issue that I would like to discuss with you, because in Brazil we have to approve a plan, we have 4 classes of creditors, and they're mandatory, and the plan can put doesn't necessarily have to treat all creditors inside each class the same way. And it has been increasingly common, even in cases involving foreign creditors, bondholders, that creditors who are willing to lend money to the company or become strategic suppliers are paid much better than the others who are not given this, who are not willing to give the same, to extend money or continue to supply to the company. And sometimes the company cherry picks the ones that they need to approve the plan to create a plan that works for the company and the shareholders, and using those strategic creditors as the majority they need to approve a plan. And the US, as far as I know, it's not possible to do that, as you have to separate the creditors into different classes. And how would that play out in the decision of choosing to file in Brazil or choosing to file in the US, right?
I think as far as I think the question ultimately depends on, enforceability and recognition, right? So I think it's going to be very fact-based. The US does, in its own bankruptcy jurisprudence, recognize that some creditors are entitled to better treatment, not just because of a statutory priority, but because they're providing new credit in one way or another, or they're necessary to the future of the company in a meaningful economic way. On the other hand, we do have a couple of important recognition cases where if the vote on the foreign scheme or plan was basically cherry-picked to favor insiders who really weren't providing anything new, then recognition might not be granted. So it really depends, I think. If it seems fundamentally fair, even if it's not the same type of classification regime that we would have, I think U.S. courts would recognize it. They might actually do a hypothetical classification scheme in their own mind or in the briefing under the U.S. law to see, how close is it to U.S. law. It doesn't have to be an exact, by any means, overlap. It just has to be, in the realm of not being outside of public policy. So I think it's fact driven, but if there's really undue advantage taking, particularly by insiders, that would present a problem.
Yeah, I think also that I agree with all that. I think also there's obviously in ancillary proceedings, the idea that local creditors, meaning like a U.S. creditor in a U.S. recognition proceeding, aren't being treated worse than other people. Ironically, in these cross-border cases, sometimes you're treated better because you're not within the purview of the court. But I think that would be another important guardrail, is that there's a sense of fairness across creditors, across geographies, just because it feels more fundamentally fair. But Judge Drain is absolutely right that there's robust case law in the U.S. that it's arguing that it doesn't comply with absolute priority itself is not a reason that you wouldn't get recognition in the U.S. I think you have to show the robustness of the system. I think there's actually also interesting case law talking about when you say it's is it a fair system? Is it a fair set of laws versus how much the court should look at the fairness of every class of claims and every individual decision in the specific plan. I think as a practical matter, you have to be ready to address both for the court. You never want to go in front of the court and ask them to approve something that just doesn't feel fair. Because judges have a lot of equity and they have a lot of discretion. And so you just have to make sure you're not asking for things that don't feel right. But there's also interesting, arguments on the side about a fair general process or a fair set of laws versus how much the court is going to relook and relitigate every line item of a specific plan.
Thank you. Guilherme, would you like to add something?
Oh, I think that goes same way here, right? I mean, I think that you also have the scrutiny of the court. I mean, and I think that whenever you have gerrymandering or other types of, maneuvers to approve the plan, court would be looking for that regardless of, the required thresholds. So I think that this control should happen anywhere.
Okay. Well, that's great. We're running out of time here. I'd like to ask if you would like to add something so we can just wrap up. It has been a great discussion and time flies, but yeah, I think it's time. So if you'd like to add something, please go ahead. Lisa, Robert, Guilherme, would you like to add something too?
Sure. I think what I would say is, first, it has been a very interesting discussion. I think a lot of the issues really have come forward that we struggle with every day or work through every day. I feel like the one great challenge in a good way is that you have two very robust, strong systems and really good options. And so this is a fun panel to have and really interesting issues to talk about, because when companies are facing distress and thinking about how to reorganize, that they have two really good choices, and they have the luxury of doing this analysis of figuring out where the right one is for them. And so I think that things, particularly with multinational groups, I think that's where the most interesting work and cases will come. But you're starting from a very strong platform on both sides, which is what makes it fun and interesting to work together on it.
Well, I don't have anything to add to that, but I do want to thank TMA Brazil. I mean, I think that organizations like this really do enhance the sophistication of what really are difficult, discussions of very difficult issues, and it's the only way in this area that you can really do it is with that sophisticated background.
Well, I think that, first of all, thank you, Paulo, for moderating the panel. Thank you, TMA Brazil. And actually, I think that I would only add that, I'm really looking forward to actual cases here in Brazil, recognition cases, because we've had like a couple of panels, discussions about recognition, but 2 years, only one case uncontested. So let's see if we get actual cases coming on, so we can test the ancestral model law here in Brazil.
Great.
Yeah.
Thank you.
And have some fun, right?
That's it.
Always.
That's it.
Always.
Yeah. Thank you,
Thanks,
everyone.
Thank you. I'd like to thank TMA Brazil. I'd like to thank our panelists, and I'd like to thank the audience for watching us. Thank you, everybody. See you next time.
See you next time.
Bye. Thank you. Bye-bye.
Bye-bye.